Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this litigation update on US v. Apple, featuring Professor Rebecca Allensworth and the Honorable Maureen Olhausen as speakers, and Deborah Garza as moderator. Deborah Garza is a partner at Rule Garza Howley, and she has served as an advisor to firms for over 40 years on strategic transactions, civil and criminal investigations and litigation, and she's the 2022 recipient of Global Competition Review's Lifetime Achievement Award. She's also served in key government enforcement and policy roles, including as Deputy Assistant Attorney General and Acting Assistant Attorney General of the Antitrust Division of the U.S. Justice Department and as Chair of the Antitrust Modernization Commission. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Near the end of the program, we will turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. And with that, thank you, Deborah, for joining us. I'll hand things over to you.
Thank you, Edith, and thank you for the very kind introduction. We'll be discussing today U.S. versus Apple with two guests, Professor Rebecca Allensworth and Maureen Olhausen. I think Professor Allensworth will be joining us in a minute or so. In the meantime, let me do a little bit of introduction of the two of them. And as Edith said, you can review their more extended bios in the on the webinar webpage, and I encourage you to do so. Both Maureen and Rebecca are probably very well known to most of you, and if you don't know them, you should know them. Maureen is currently a partner in the DC office of Wilson Sonsini. She also spent 12 years at the Federal Trade Commission, first as a very consequential head of the Office of Policy and Planning, and as a commissioner and an acting chair of the Federal Trade Commission. As head of OPP, she chaired the Internet Task Force, which produced a very influential report analyzing competition and consumer protection issues in the broadband and internet sector. So Maureen was really thinking about all these hard issues back at the beginning. And I have to say that I find that her thoughtful analysis of these issues and her writings have been really helpful, and she's been, for that reason, really very influential in development of the law. And so we're lucky to have her here today. Professor Allensworth is an antitrust scholar in her own right, whose work focuses in part on competition policy as it relates specifically to tech platforms, as well as professional licensing. Her work has been cited by the Supreme Court, and she has been recognized for her groundbreaking antitrust scholarship. So we have two speakers very knowledgeable in the area today. To make the best use of our limited time while we wait for Professor Allensworth, I'm going to just do a very brief summary of the U.S. versus Apple case, just so that we have the context for the discussion today. In March of this year, the U.S. Justice Department and 16 states filed a sweeping complaint against Apple, alleging that it has monopolized and attempted to monopolize the U.S. market in the U.S. for smartphones and performance smartphones. At issue is an array of current and past Apple policies and restrictions that govern the way that third-party applications access and engage on the iPhone platform. Plaintiffs claim that Apple's failure to open its platform prevents the development of super apps and cross-platform functionality that would make it easier or more attractive for Apple users to select or switch to rival smartphones. According to the plaintiffs, this inability, the stickiness and inability to switch has had an effect throughout the industry in suppressing innovation and better features and apps for the iPhones. In contrast, Apple characterizes its practice as a pro-competitive way to differentiate its products and make them more attractive and safe and secure for consumers to use. The case is just beginning to get moving. Apple recently was permitted to file a motion to dismiss, which will be coming up. Apple says that it intends to address all of the claims in the case in its motion to dismiss. And it appears that they will challenge the claims under existing Section 2 jurisprudence governing companies' duty to deal and design choices. So that's a very quick summary of the case. Maybe we'll get to some of the more details of that in our discussion. And I'll start with Maureen. So Maureen, the Biden administration and the Trump administration have been very different in terms of antitrust enforcement, but they have one common area in that they both have focused significant resources in investigating large tech companies. The wide-ranging conduct investigations of Apple, Facebook, Amazon, and Google all reportedly started under the Trump administration, which brought the first Google case challenging Google's search products, as well as the Facebook case, or Meta case. From your perspective, how is the Biden administration's enforcement philosophy for high-tech platform markets different from prior administrations, particularly the Trump administration, which also has a deep skepticism of big tech?
Deb, thanks so much for the question, and thank you to the Federalist Society for having me here today. I'm delighted to be on this panel talking about these interesting topics. I think that there is this overlap between the two administrations of a focus on some of the biggest players in tech, right? So we, as you mentioned, under the Trump administration, they started investigations of, a handful of the biggest players. And as they've brought forward the cases under the Trump administration, I think they were focused more on traditional types of antitrust law theories, right? So I think in the Meta case, it was monopolization through a series of, through acquisitions that, sort of later on, according to the complaint, were seen in a different light than when they were reviewed by the commission, but less this idea of a focus on tech's obligation or platforms' obligation to interconnect with their rivals, to avoid things like self-preferencing. Self-preferencing is not really an antitrust term, but we're starting to hear about it in antitrust. I think it's the Biden administration in its approach is taking a more regulatory type of approach of regulating the platforms, almost like a utility style regulator, like we're seeing in Europe occurring with, the digital regulation over there. And I see there, of course, this is Apple is a DOJ case. All they have is, they can't rely on unfair methods of competition like the FTC to try to broaden what might be a violation. But I see the way they're arguing things, they're deploying these theories. I think they're looking to that idea of, an obligation to interconnect, interact, help your rivals in a way that I think is a little different than we've seen previously accepted in antitrust. And as for tech more generally, so kind of outside these collection of cases, in my impression in the Biden, in the Trump administration it was the big platforms, that were the focus. In the Biden administration, they're certainly still focused on those platforms, but they are also taking, I think, a much broader brush approach to scrutiny of the tech, what we might even consider little tech, right? Not just, or medium tech. I see concerns there, and they're talking a lot about things involving, they say things like, well, we kind of missed things when the internet was first getting started, and we don't want to miss those same kind of things. We want to intervene earlier, and we want to be more involved in, like, AI and cloud and the stack for that. And I think so they're looking to go sort of with broader theories earlier in the development of new technologies. And it's also kind of a piece of skepticism I think across the board, or maybe a just more critical lens put on business conduct more generally. So it's not limited solely to tech. I'll put it that way. But certainly tech has been a rather large focus for the current administration. And you know, and we'll see how these cases play out. I mean, it's interesting because we have the Trump cases still, you know, rolling through. We have the new cases. You know, and then we have attempts in Congress to actually change, you know, in 2021, 2022, we saw attempts in Congress to really change the antitrust laws, right? And to kind of embrace these more regulatory theories for the behavior of big platforms, for how big platforms have to deal with competitors who need access to the platform or want access to the platform. So I think some of that sort of, like, while it didn't get through in Congress, I think there's an interest in trying to develop those same obligations through these cases.
So Maura, I do remember back in the sort of the 80s and 90s, there was a concern by regulators not to intervene too early, right? So there was a little bit of regulatory humility, if you will, and a desire not to influence who would be the winners and losers, and not to inadvertently suppress innovation by doing something that was too soon, right? And there was also a sense of the nascent industry development, et cetera. But of course, as you mentioned, now the Biden administration antitrust enforcers have said, well, but you missed things, right? You were asleep at the wheel, and what you didn't see, you know, you didn't catch, and now we've got these super platforms with moats around them. So I guess my question to you is, since like me, you were there at that time and were focused on these issues, did prior administrations miss something, in your opinion? What was there a basis, and would it have been good to do something to set the rules for competition for the platform or competition on the platform back then?
I think that it's important to do retrospectives and to actually put some data behind those kinds of assertions. I think it's kind of easy to say, right? Like, oh, you know, look, we have big players and we don't like big players because, you know, for whatever collection of reasons, one might not like having big tech platforms. Ergo, something was missed, you know, early on. And so I'm not defensive to say, look, there's certainly, that's possible, right? But can somebody sort of show the example of where it was missed and how it was missed, and put some data beyond it, beyond, I think, merely kind of a broad, like kind of a broad statement like that. I think one of the, you know, we're seeing that it's also can be a little hard to untangle some of that, because companies become large and effective for a lot of different reasons, you know, including, we talk about network effects, we talk about technological innovation. On the merger side, so I know this, you know, the Apple case is not a merger case, but on the merger side, I think there is this, you know, idea that, well, a bigger player bought a smaller player and then sort of brought that into the fold, and then it became a very, you know, important part of the platform. And that had that smaller player just stayed independent, they would have grown up to be this big, you know, giant killer, right? And I don't think you can really make that, you know, make that presumption. One of the reasons we know that smaller startups kind of what they run into is that, you know, at some point, yes, they may have a great idea and they may have, you know, some smart people working on it, but do they have the professional management? Do they have the resources? Do they have kind of the ability to grow it into that big, you know, successful part of the business? And kind of even going further back in the chain, without having sort of that exit strategy for the smaller players, does this whole system even work? So anyway, just a way to say, like, I don't think you can, I'm not saying that it's not possible, but I don't think you can just say there's something in the market I don't like today, ergo antitrust failed in the past.
So one of the things that Professor Allensworth has written about, and that we would talk with her when she joins, is this difference between competition for the platform and competition on the platform. So there's a period of time in which you have competition for the platform, in which you're basically trying to present a product that consumers will buy into, and you're trying to make it attractive. So for example, with Apple, they start out with the iPhone and or the iPod, I guess, and then the iPhone. And their job is to basically build something that people will want to use, right? And to develop the apps that will bring everybody together on the platform, et cetera. At some point, and so they win the platform, right? So they succeed and they do what we want them to do by building and offering a good product. And then you switch to competition on the platform. When does that happen? So if I'm little tech right now and I'm coming up with some killer app, or I'm coming up with something, at what point do my antitrust obligations and the rules of the road change for me?
Yeah, that's a really good question. A couple of years ago, I wrote an article, a paper actually. First it was a speech and then became an article, a paper called Brother May I, the challenge of competitor control over market entry. And that's something we've seen really throughout antitrust. And one of the areas that I talked about in that case, in that article, had to do with this question of, like, if I need access to my competitors' infrastructure to compete with them, what are the obligations there? And I think that's sort of what we're looking for in the Apple case. That's really teed up very clearly in a way that some other cases, the Brother May I cases that I had talked about, were more about a monopoly. Like, so first of all, you need market power, right? You need to be able that your decisions are going to affect competition in the market. You're large enough for that. And case law has set that bar pretty high. I think that there's sort of a question of whether it has DOJ made out a market for performance smartphones that a court will accept, right? But basically that's a threshold. You have to have, I think, market power. Then I think the question is there just it's useful for me. I would like to have access to that platform. It's cheaper for me as a rival. It's, I just prefer it. Or is it actually like, that's really the only way to enter the market, right? Is that, I think it is a key question there for competition on the platform. I think courts have been pretty reluctant to say that there's some sort of obligation for a competitor to just simply give access to rivals because rivals want it. It's, it kind of goes back to some property rights ideas and independent, business judgment. So I think that's one of the questions that really comes to the fore in this type of case versus some other cases, like I think about the McWane case that when I was at the FTC that we brought and won in the 11th Circuit. And that was more about a classic distribution, like exclusive dealing, saying if you buy from us, you can, and someone who has market power, you can't buy. If you buy from our rival, you can't buy from us. That kind of thing. And that is not really what's at issue in the Apple case, but that's certainly one where of this kind of, single firm conduct kind of question. So here, I think it really brings up all these interesting issues of, do they have market power? Are they the only door to the market? Are their refusal to basically give rivals access on the conditions under which the rivals prefer? Is that anti-competitive? Or is that, how does that balance with basically their own decision? So I think that those, we'll talk more about those kind of questions, but I think that is like kind of classic competition, on on the platform kinds of issues that need to be hashed through in the courts.
Which brings us to the next segment of our discussion, which is what will be the key issues of fact and law in this case. The government's core allegation is that Apple has anti-competitively refused to permit third-party developers access to the iPhone platform. Apple has raised cases like Trinco and Aspen on refusal to deal. They've also raised, I think they're also trying to maneuver around the Amex case in talking about, trying to distinguish this iPhone platform from the kind of platform that was a transactions platform, to argue that that when they look at efficiencies, it's net efficiencies on both sides of the platform. So there are going to be a lot of issues of law and fact. But my question to you is, what do you see as the most significant issues of law and fact that will have to be addressed in this case as it goes forward?
So I kind of putting the factual issues first, because I think it really drives the legal analysis. And that's also something that drives me crazy, is because people often, it's like antitrust is like intensely factual kind of inquiry. But so rivals want access to Apple's platform under certain terms that the rivals prefer. I think there are some important questions in there, which is, so first of all, has Apple ever provided access on those terms to others, right? So that's kind of the classic, was there a prior course of dealing that now has been abandoned? And there, you can have some presumptions that it was previously a profitable thing and that now it's being abandoned for, anti-competitive reasons and the profit sacrifice test and like all that goes into that. So I think that's an important question. And then, is this something that would be hard, right? We see this in the Trinco case and some other cases, like, this is not just like plugging in, a cord to a plugging something in, right? That's already ready-made there, right? And they have, a price and sort of like, that's already been established, right? So I don't think we have that in this case, but that's an important factual thing. Then are there reasons why Apple, pro-competitive reasons, has created the system the way that they've created it? I think that's another really important factual thing. So once we have those factual things, then I think we flip to those legal questions, which is this like Aspen Skiing or Otter Tail, where they were offering this product, service, what have you, access in the market for a price, and they turned away from it? Is this a choice that was made specifically to just thwart competition and doesn't have other pro-competitive reasons, quality, safety, kind of what have you? And then I think there's also the question of, does this system, the way they have it, make Apple's own product work better? Does it make the phone work better? Because as we look at cases, like we look at the Microsoft case, this question about the Java, right, thing was like, well, yeah, they changed it, but it made Microsoft's product work better, so the court didn't find liability there. So that's, anyway, that's sort of like the facts should then lead to what the correct legal analysis is.
Okay, and Professor Allensworth, we were just talking about the issues that are likely to be determinative and hotly contested in the case. If the government's able to meet its initial burden, Apple's defense will likely focus on pro-competitive, as Maureen was suggesting, pro-competitive justifications for the policies the government has challenged. And early advocacy by Apple suggests that privacy and security will be a prominent part of its defense. How do you think the court is likely to weigh Apple's defenses based on privacy and security, and how much will the judge test privacy as a justification?
So thank you. First, let me thank the Federalist Society for inviting me and also sincerely apologize. Sometimes when I adjust things for Central Time, I add an hour and sometimes I subtract an hour. One of those is correct, and I did the wrong one today. So I'm really sincerely sorry about that. And I'm sorry to have missed the beginning of this discussion. But to answer your question, the pro-competitive justifications are going to be crucial here. And, some of the things that Maureen said, I think, are correct in terms of how litigation is likely to go. There will be argumentation about whether or not there was a prior course of dealing, and there will be argumentation about whether or not the things that are not being provided in terms of access could easily be provided or are easily found on the market. However, I would argue that neither of those things are elements. They're not required. The question here really is, are these product design choices primarily motivated by an idea of exclusion, or are they really about delivering consumer value? And that question is aided by questions about, did you have a presumably profitable course of dealing? Is this something you could easily provide? In fact, you provided at retail terms to others. That question is furthered by those things, but I just wanted to be, I wanted to get out there the idea that it's not my view that is a part of the initial burden that will have to be carried. The initial burden will be, is this something that makes it harder for other people to compete? Then it will shift to this very crucial set of pro-competitive justifications. And on my view, this is where the case is going to be won or lost. So Apple is fortunate in the sense that it has a long-standing reputation of valuing privacy, and of doing a sort of integrated, streamlined design where everything works together and therefore doesn't always work perfectly with things outside of the ecosystem. The idea that Apple has cultivated from the beginning is that it is an ecosystem, that you can trust everything within it and everything works well in terms of interoperation. It was a competitive offering at the time to the more kind of open texture, maybe not open source, but more open environment of the Microsoft universe. And so that gives it a head start. That gives Apple kind of a head start for these pro-competitive justifications. On the other hand, at least what we know from the complaint is that the government is going to be prepared to argue that these are pretextual. So this will be a very fact-heavy set of questions that the court will want to see answered in deciding whether or not it's carried its pro-competitive justifications.
So let me go back to what you were talking about in terms of the government's initial burden, which I think you characterized as did it make it harder to compete. But to be more precise, I mean, I assume that the government has to, and they have alleged market power, right? And they base that on revenue-based market shares in sales in the U.S. for the smartphones and super performance phones. And then I think, don't they have to allege exclusionary conduct? I mean, is there a difference between alleging exclusionary conduct and alleging that they made it harder to compete? Where do you draw the line?
Well, it's a great question. I mean, yes. So, for example, in a different case, in the Amazon case, it's awfully hard to compete with Amazon because nobody has the distribution systems that Amazon has. That does not sound to me like a great case for a plaintiff, whether the government or otherwise, to bring as an initial matter. But the closer we come to asking the question, is this exclusionary? The more I think that we're tempted to collapse and I think this is actually what courts do, to be quite honest, collapse the whole inquiry into that question. Yes, the question in the Section 2 case is this exclusionary in a way that gives you a competitive edge by disadvantaging your competitors without any pro-competitive justification. That's not, having the best distribution system. That's not competing on the merits. So I guess part of what I'm saying is I resist the idea that this burden shifting system does a lot of work. I think even at stage one, if that's what the judge says they're doing, they're thinking about the pro-competitive justifications and asking the question, does it make it harder to compete? So in that sense, I sort of agree with you. But the way in which I disagree with you is that is this idea that there's a tight burden shifting question, which is first the plaintiff has to make its arguments, putting all of the pro-competitive justifications in this little box for later. Because of course, they're part of that initial question of, is this exclusionary in a way that antitrust law is prepared to condemn?
Okay. Maureen, do you have anything to add to that?
I mean, I think the Microsoft burden shifting approach is pretty well accepted, but I do agree that sort of psychologically, like when a judge is looking at this, I'm not sure it's as airtight as it might suggest. But I think you're right in that regard, that while there is this framework, and I think the court is likely to follow it, it's hard to just completely cleave those things off, because I think you're right. There is this question of, is it, a pro-competitive design choice, or, however you characterize the choice that they made, whether it's design or, business choices or things like that.
Right. And so I guess going further we talked about this a little bit before you joined, Professor Allensworth. So in the Amex, there appears in the complaint, it appears that the DOJ is anticipating and trying to differentiate itself. Its complaint against the alleged Apple iPhone platform from the kinds of platform that the Supreme Court was talking about in the Amex case. So in Amex, in the American Express case, which involved a payment systems platform, the court held that when you're looking at these pro-competitive justifications and efficiencies, you have to look at net efficiencies. So you've got to look at efficiencies on both sides of the platform in that case. You've got to look at, for the banks and the vendors and the consumers. Here, the DOJ in the states seem to be positioning to say no net balancing. They say that this is not purely a transactions platform. People select an iPhone because of the other sort of features and functionality have nothing to do with transacting. And so therefore, we're going to look at the efficiencies on that side of the platform, if you will, and each side separately. Do you have any views on that, and how the court is likely to sort out, in light of Amex, what they need to do when they're looking at these competitive justifications and alleged asserted efficiencies?
Well, I think this is actually kind of connects very nicely with the point I was trying to make earlier. So in fact, the holding of Amex kind of does the thing that I think the burden shifting framework is trying to push against, which is it does it kind of all in one chunk. And I think that what you are likely to see is Apple using the holding in Amex to its benefit, to say you have to look at this all at once. At step one, you do the whole thing. You decide whether or not this is pro or anti-competitive on balance. And like I said, there is some precedent for that. And the government will argue, no, we go stepwise, we go, and we don't have to look at it all at once. But yes, it's sort of the smushing together of the two sides of the platform that I think Apple will try to make. Try to, sort of like, don't look over here, look at the whole. Do you like your iPhone? Does it work well for you? Is it a popular product? Oh, great. Okay. So, we can agree Paris is the capital of France. Now we move on to the next thing. And then I think that the litigators on the side of the government will be doing everything they can to dance around American Express. I think there's a real sense that American Express was an overreach. Now it is a Supreme Court precedent, so overreach or not, it's the law. But I think this will be an important opportunity for the courts to clarify what exactly American Express meant when it defined the market by including the platform and not the two sides of the platform.
Thank you. So another issue that's common in many high-tech antitrust cases is the latitude that a company has to pursue its preferred design choices. For example, Apple may want a closed ecosystem, and we referenced this already, because it may make it easier for customers to use its products, such as having a smartwatch automatically sync with a cell phone, etc. How does a court draw a line between design preferences of a company and where those choices may also be anti-competitive? How does the court weigh any anti-competitive effect with the pro-competitive benefit of ease of use, particularly when it comes to technology that can otherwise be difficult for many consumers to use?
So Design choices are not per se legal, right? So it's not that you can do anything, but it is very, very rare, I think, for a court to say a design choice is it's often used the term a predatory design choice. Where there have been cases like that, there was one, I think it was called CR Bard, and it involved redesigning a needle gun for needle biopsies. And the competitors' needle cartridges fit in it. They redesigned it so that they didn't fit, but there was no quality improvement. Right, that's kind of what the court found. There was another one that involved I think it was an Alzheimer's drug, to go to a single day dose rather than a twice a day dose, and that created a problem with generic substitutability. The generic was of the twice a day dose was about to enter the market, and the court found that design had was an antitrust violation. Though I think that one is pretty debatable, because there probably is some benefit to having a single day dose for those kinds of medicines. But it's pretty rare. So if you just design your product in a way that is like an improvement, right? Is just an improvement, and everybody's sorry, you got to catch up later. It's improvement. Courts have been very, very hesitant to say, no, you foiled, competitors who were kind of relying on your previous design. They can't interoperate, or whatever, reason they're relying on your design. That alone, the effect on competitors is not sufficient. It really has to be something where it's designed with no real benefit for improvements for consumers, and it is simply designed to foil competitors. So I think that is, like I mentioned in the Microsoft case with the Java virtual machine. So it was incompatible with rivals, but it helped Microsoft's product work better. The court said, well, that's okay. So I think it's an area where, in this case, it might be, I think, particularly difficult, because Apple, its whole approach is the closed system, is the easy, kind of, curated kind of approach. So I'm not saying that it's impossible, and maybe there's evidence and documents or something that show this is solely to foil competition, but that is not something that I think is intuitive about how Apple operates and how it has consistently positioned itself over time.
Rebecca, I think you've thought about these issues and thought about in the context of, concerns about competition for the platform versus on the platform. Do you have any comments on that?
Yeah, so I mean, I agree with everything Maureen said. If what we're observing is the holdings that courts have made very fact specific over the last few decades, and if you look at those, the constellation of those, and the one I really think of is the T-Core case, or it's not, that's a totally different case. I think it's Tyco. Anyway, it's the heart rate monitors that aren't compatible with the heart rate machines. It's actually very similar to the needle case, and the court's very deferential there to product design choices. The thing that I guess I do want to push back on is, I think that this deference to product design, this policy that courts have been pursuing, that's not particularly spelled out in the antitrust laws, that's not particularly spelled out in the antitrust case law prior to 1980, is really coming under pressure right now. I think there's a mounting recognition that giving companies carte blanche in terms of their product design choices has the potential to really impair competition. And it will impair competition in one of two ways. One, for the platform. So if you can design your platform however you'd like, as long as you raise some even flimsy pro-competitive, good for consumer product design argument, then you make it harder to topple that platform competitively. And if you design your platform to be very exclusionary of other companies that might sit on or use the platform, then you're not going to have competition on the platform. This realization that the policy that courts have pursued by being so deferential on the facts, and that's a point I want to get to in just a second, on the facts over the last 40 years is going to put pressure on courts to adjust the way they decide these cases. Will it be enough for the government to win in this case? I don't really know. But I think the key thing here is that everybody could agree, even over the last 40 years, that a product design choice that is designed and has the effect of primarily being exclusionary without really having a significant offsetting benefit to consumers is potentially a bad act under the Sherman Act. The way that the courts have kind of gotten around that for 40 years is to say, well, we'll accept any argument. Any argument you want to make about how this slightly improves the product, we're going to go for it. We're not going to roll up our sleeves and balance it against the anti-competitive effect. We're not going to try to figure out what you were really thinking. I think those two choices are not necessarily going to survive this current moment that we have of pushback against the laissez-faire. I'm not sure the courts are going to maintain their willingness to turn a blind eye to what's really going on behind these business decisions.
So I'm glad you referenced this current moment, because that lets us segue into the next part of our discussion, which includes the fact that we're going to get a new administration one way or another after November. Do you think that the change in administration will matter to the Apple case? I mean, based on what we know about at this point, what we know about whether Kamala Harris would continue to pursue the current approach of the Biden administration, and what kind of approach would occur in the Trump-Vance administration. Do we have any sense of whether we're going to see a swing of the pendulum back, or continue the momentum that exists right now? Either one of you.
Maureen, you have the longer view on this. I'm interested to hear what you think.
Well, my experience has suggested that the antitrust agencies don't immediately, if there's a change in administration, don't necessarily immediately come in and kind of stop the presses on all the current enforcement action, right? They may review it. I mean, sometimes there is like a real sea change, maybe when the Reagan administration started, and Deb, you probably have more experience being in closer to that. So I think that there will be the cases that are in court happening. Well, I think they'll continue at least for a while. I think that there may be some preliminary decisions that get made, right? And also whether there is a decision that maybe a case should get settled. Maybe there's a way for something to kind of get resolved. So you think about the Microsoft case, right? There was an administration change, and then you did have, after the court decision, eventually kind of a settlement with remedies. So I think these cases will not immediately, get thrown out the window if there's a Trump administration. And I also think a lot of this inquiry started under the Trump administration, and so it may, and particularly of these large platforms. So who knows? They may just be like, keep going, right? Or so I think it's a little bit hard to tell right now, other than I don't anticipate some sort of immediate stop.
Okay. So though it is early, the record suggests that any remedy is likely to be behavioral in the Apple case, which is reminiscent of US versus Microsoft settlement from 20 plus years ago. How does the range of likely remedies in Apple compare, Maureen, to the Apple settlement? And should the Biden administration use the Microsoft settlement as a roadmap to address the issues in Apple? And clearly the complaint relies on the Microsoft case to a substantial extent, making the assertion that Apple, after all, benefited, in the government's view, benefited from the settlement in the Microsoft case by being able to have iTunes on the Windows platform, which helped with the launch of and success of the iPod. So what would you predict would be the likely course here with respect to remedies, and how significant is the Microsoft settlement to trying to figure out what remedies might be? And did you think that do you agree that the Microsoft settlement was a success?
So starting with your last question first, I don't think the Microsoft settlement is necessarily considered as a very successful settlement, right? I think that, and it really brought up a lot of issues of administrability, which we also think about with the AT&T breakup and things like that. And going, I think, to some of these questions also about product design, and if this product isn't already on the market, and at what price and under what conditions, like how does a court decide, like what's the right price, what are the right terms, what are the, a court saying, well, how do I know what's, the technical interoperability, kind of things is the right decision. So I think a court is going to consider pretty carefully administrability. And I think that, the Microsoft remedies, I mean, some of them, let's offer the same product, one with reduced capabilities for the same price, like surprise, people didn't choose that option. So, but I don't think that's really quite an issue here. So I think, I don't think a structural remedy is so, I mean, this isn't a merger case where we're like pulling back apart two entities who had been previously separated, right? This would be kind of dividing up a company that grew organically and consciously to have this. So I think behavioral is really all there is, and I think it would have to be the type of remedy that would be easy to administer, that would say, you can't have X or Y terms in your contract, and kind of go from there. But once you start getting into pricing, once you start getting into technological kind of connections, I think it might be a little hard for a court to say that they know how to do that appropriately.
So one of the things, one of the things that the Microsoft settlement involved was I've forgotten now what it's called, but a tech committee. There was an element of self-regulation, and I'm raising this, Rebecca, because I know that's another area that you focus on, which is industry self-regulation, right? And we didn't discuss this previously, so if you don't have a view on it, that's okay. But and I was around during the Reagan administration, and I'm acutely aware of the problems of administrability with respect to the breakup of AT&T. That was a nightmare. But do you see, Rebecca, a way to kind of deal with that administrability problem and use some form of self-regulation or reporting, or a tech committee or something here for Apple?
Well, I'm very skeptical of self-regulation. I think most antitrust people would be. In my other life, I write about professional licensing. I actually have a book coming out called The Licensing Racket. So that gives you an idea of what I think about self-regulation in the professions. I think that we are at the beginning of an era of courts rolling up their sleeves and doing a little bit of this forced sharing. Even the things that Maureen's identifying of, in your contract, you can't have this, you can't have that, that could be characterized as forced sharing. And all of the downsides of courts getting involved with figuring out, how much you should share, on what terms, with what kinds of competitors, all those downsides are real. But I think we're at the beginning of realizing that there are some really serious downsides to not doing that at all. And so these questions of administrability, I think, are well made. But when you say that the AT&T breakup was a nightmare, you could mean one of two things. You could mean that it was an administratable it was a nightmare from an administration perspective, or you could mean that it was a failure from a perspective of opening up competition. I think the second point is pretty controversial. I think a lot of people would argue that the AT&T breakup actually did eventually, and as messy as it was, make telecom more competitive and kind of pave the way for some of the telecom innovations that came after that. And so the question is it worth the nightmare for the, longer term better state? And I think the other thing is, since we're at the very early stages of figuring out through case law, through, by Braille, really, how to do these forced sharing cases, settlement by settlement, consent decree by consent decree, there will start to be some sort of precedent and some sort of norms around how it's done. And then it will become easier for companies to know what they can and can't do. And it will not be courts having to regulate every single, it won't be self-regulation, and it also won't be direct regulation by the courts. It will be something that people can pull out of the case law and pull out of the settlements to understand what is on and off the table. So, I mean, I guess I don't have an easy solution for how to come up with an administratable way to do some forced sharing. First thing I would do is probably not call it forced sharing. But at the end of the day, that is kind of what it is.
So just to be clear on the what I meant by in the AT&T decree, one of the things, for example, in the decree was to limit the lines of businesses in which the RBOCs, the regional bell operating companies, could engage. So you had antitrust division lawyers and economists looking at applications by the RBOCs to enter into lines of business or to engage in certain, use certain technology. And then that needed a recommendation, then it had to go to the court. And the problem was antitrust lawyers and economists are really not well placed to assess those kinds of applications, right? And ultimately, we had, piles of backed up applications by the companies that was essentially holding up their business operations, and not a very good way for us to make a judgment or for the court to make a judgment about the impact of going into these lines of business. So you basically had antitrust enforcers standing there as part of the process of innovation, right? And how it was going to work. And that was the nightmare part of it. I think it really highlighted the difficulty that I think Justice Breyer had noticed and had talked about in some, I can't remember the decision, but the difficulty of courts and antitrust enforcers of really engaging in quite focused regulation of a company. So it is a really hard problem. And now Rebecca, before we wrap up, I want to talk to you a little bit about how the EC has approached this issue. So Apple has faced scrutiny from the EC. In addition to fines, they have been ordered to undertake a series of behavioral remedies. I guess, to what extent do you think that the Biden administration is influenced by these international antitrust enforcement efforts, and how might that change the way that we in the U.S. Tend to look at these things? What do you see them importing from Europe, which has quite a different system from ours?
Yeah, well, I mean, it's a little bit of a proof of concept, I did a lot of interviews with the media on the day that this lawsuit dropped, and my favorite one was from abroad. I think it was a British outfit said, why is America suing its most successful company? Why is it trying to destroy the golden goose? And my answer was, they're not trying to destroy the golden goose. Apple is it's not going to be a breakup. I totally agree with Maureen on that. They're not trying to destroy Apple, and Apple's under these kinds of regulations in Europe and still able to do well and compete there. So it's a bit of a proof of concept, but it's also a political liability. Not a lot of Americans want to be seen as further aligning themselves with the regulatory system in Europe. I mean, maybe some, progressives are happy to embrace that, but it's not gonna fly bipartisan. Hey, let's model our antitrust laws after the European system. And so I think the key thing here will be to put it in terms that I think are really real, which is about innovation. I think that America's all about the next great idea. I think America's all about competition that leads to new ideas. Apple was started in a garage or a dorm room. I forget, everyone's a garage or a dorm room. The question is, how can we create a competitive environment that lets those garage and dorm room businesses thrive? And I just want to, again, highlight that the kind of innovation that the agency stood in the way of, that you were describing with the AT&T case, that's a very important kind of innovation. But there's also another kind of innovation that regulation actually empowered. So how are we going to balance these two different kinds of innovation? One, the big incumbent companies, making new and exciting products, giving a lot of money to R&D. That's an important kind of innovation. And then the upstart, next big thing, new thing that needs access to the network, to the platform to compete, also important. I think we're increasingly seeing that. So you were asking about Europe, does Europe strike the right balance between these two things? I'm not sure, but they talk about it in those terms. They recognize that there's two different kinds of competition for the platform and on the platform.
I guess my final question is, does the US versus Apple case really matter, given a very assertive, aggressive European approach? I mean, if Europe is taking the lead in regulating digital markets or platform markets, and Apple has to play globally, doesn't matter. I mean, are we just being overtaken? Is Europe basically setting the standard for regulation of these markets? Maureen, do you have a view on that?
I mean, I think that's a really good question. And I also think earlier on in the discussion, I mentioned that I like empirics. And when you look at the European approach and you look at European innovation and development in the tech industry, the difference is stark, right? It's all happening in the US. Right. And that is increasingly so. I mean, there's a very stark divergence. So I think it's an important question to ask, which is maybe they're doing that, but isn't that the right answer for consumers and innovation and for the race that we're in with, rising competition in these important areas from China? Right. So I think, that's a really, really important question. And to the bigger question of, where do we want to end up?
Yeah, how much control? That was one of the things that triggered the formation of the Antitrust Modernization Commission, which I chaired, which is basically whether we were, in part, it was a question of, is our antitrust policy ripe, and does it even matter what's happening with China and in Europe? So there's a lot to see. Maybe we'll have another one of these. Maybe someone else will moderate it, but maybe we'll have another one of these after Apple has filed its motion to dismiss, and we see the briefings in that case and see the initial court ruling. But thank you very much, Maureen and Professor Allensworth. It certainly has been educative for me and enjoyable. Edith?
Yes, and on behalf of the Federalist Society as well, thank you to Maureen and Rebecca for speaking and Deborah for moderating. We appreciate you giving your time and expertise today. And thank you also to our audience for joining us. You can stay up to date with announcements and other webinars on our website, fedsoc.org, or on all social media platforms. Thank you once more for tuning in, and we are adjourned.